Hi, letters of administration is the process where the close family members apply to the court to get permission to deal with a loved one's estate. You apply for letters of administration if your loved one did not create a will. If your loved one had a will, then you will need to apply for probate. Click on the link to access more information about probate. Letters of administration is a formal document with a special court seal, and having that document gives you the power to access your loved one's finances and access information about your loved one's estate. It gives the person who applied the power to do anything that your loved one could have done if they were alive. When is it required? You don't always need to apply for letters of administration to finalize a deceased estate, but you will need to apply for letters of administration if certain factors apply, such as if an organization told you that you need letters of administration to access money or assets or information. For example, the ATO, a super fund, or a bank have told you that you need letters of administration. If your loved one has real estate in their sole name, or if they own real estates as tenants in common with someone. If they have a significant amount of money in a sole bank account, usually over a certain threshold, such as $20,000 or $50,000, but it varies from bank to bank. Who applies for letters of administration? When someone dies without a will, their assets are divided among the closest family members. Now, who gets what depends on who is left alive. The family members who are entitled to inherit are the ones that can apply, provided they're over 18. This is usually the spouse, an adult child, a parent, or an adult sibling. Generally, you only need one person to apply on behalf of the family, but there is no restriction on how many people can apply. So 2 people can apply as well. The person who applies for letters of administration will be responsible for finalizing the estate and completing all the administrative tasks that need to be done. That person is called the administrator, and that person should be good with paperwork and should be prepared to undertake everything that needs to be done to finish everything off. If you're unsure who needs to apply, contact us and we'll have a free discussion with you to let you know who the correct person is to apply for letters of administration. We have lots of information on our website that you can read so you can understand the process better. How does the process work? To apply for letters of administration, court documents need to be prepared and signed. Estates Plus can help you prepare those court documents and get it right. Once the court documents are prepared, they are signed and then lodged with the court. The documents generally need to be witnessed by a justice of the peace. Once the court documents are filed with the court will review them and make sure everything is correct. The job of the court is to make sure that your loved one's assets go to the right people. And the right people are the ones that automatically inherit if there is no will. Applying for letters of administration can be a complex and difficult task. There are lots of court documents to prepare, and it's important that you get them right, because if you get them wrong, then the court may reject your application and it may cost you time and money. At Estates Plus, we're experts at preparing letters of administration applications. We do this day in, day out. We can make the process way easier for you. Our job is to make sure that you get your letters of administration grant issued so you can go and access the money in the estate and access the inheritance. To get the process started is quite easy. All you need is just the death certificate. We will then get the information from you that we require. So we'll need information such as a very brief snapshot of the assets and liabilities of your loved one. We don't need valuations, and it's okay if you don't know everything about the estate. To get the process started is really straightforward. Get in contact with us to have a free discussion about what information we need from you. We also check that the right person is applying for letters of administration. Sometimes the right person who's applying, the administrator, needs a helping hand from other family members, such as children, and that's okay. We often collect all the relevant information from other family members, prepare the documents, get everything in order, and the person who needs to apply just signs them. Another important process of applying for letters of administration is getting consent from all the adult people who are entitled to inherit under the estate. When you make a letters of administration application, the closest family members should all agree on who needs to apply, and anyone who's over 18 should sign a consent document saying that they're happy with that person to apply to the court. Now, if you cannot get a consent from the immediate family, that's okay. We have a process where we can still apply for letters of administration without having that consent document. Another important step for applying for letters of administration is to make sure that there is no will. So you want to do some brief searches just to make sure that your loved one did not create a will during their lifetime. Some applications are a little bit more complex than others. Here are some examples of how your application could be a little bit complex. For example, the person applying is based overseas, if the person died overseas, if the person applying cannot speak English, if translation of important documents is required, if a person who is entitled to inherit is under 18 years of age, special arrangements need to be put in place to make sure that that child actually gets their inheritance. If important documents are missing, or if you cannot get consent from the immediate family members. We can still help you despite any of these complex issues. We can often tell you really quickly how simple or complex your application will be. It simply involves a free discussion with our legal team so you can understand exactly what's involved and the process from here on. Once you start the process, we will start collecting the relevant information from you. Once the court documents are prepared and lodged with the court generally takes 3 to 6 weeks to review it. And if everything's in order, the letters of administration document will be posted directly to you. Sometimes the court has questions. These questions are called requisitions. So for example, the court may want to know more information about certain situations. If that happens, we're able to assist you to resolve and answer these requisitions so your grant gets approved. At Estates Plus, we can provide as much service as you require. Some people only want us to prepare just the letters of administration documents, and they can take care of the rest. Others need a bit more help and require us to take care of a lot more. We're happy to provide you as much assistance as you need, whether you need the full legal service and the lawyers to take care of everything, or whether you just need the court documents prepared so you can take care of it yourself. Using Estates Plus is often a better alternative to doing it yourself. Doing it yourself often involves a lot of research, a lot of reading, trying to figure out difficult concepts, whereas using our services, you can get it done much quicker and easier. And remember, our fees are reimbursed by the estate. So whatever you spend on using our services, you're entitled to being reimbursed from the estate when the money comes in. The easiest way to get started is to contact us for a free discussion to find out what you need to do. This is absolutely obligation free. Often we can let you know whether you need letters of administration or not, and we can give you some guidance on some questions that you might have about the process. Any costs associated with applying for letters of administration are expenses related and covered by the estate. So whoever paid this money will be reimbursed before the inheritance is distributed to the other family members. If your application is straightforward, then you'll only be charged what's quoted on our website. We will let you know how much it costs up front, so there are no surprises. Our fees are fixed, and our fees are so much more affordable than other legal services. We make sure our fees are 70 to 80% cheaper than using another law firm. The reason our fees are lower than elsewhere is because we specialize in this area and we do this day in, day out. we're able to do the job much quicker and better than other law firms who don't have our level of expertise. We make sure that all the documents are fully ready to file. There are no templates and there's nothing for you to fill out later. Everything is ready to go. Our documents are prepared to your unique circumstances. The information that you need to provide us for us to prepare the documents is really simple. We need some basic information about the family. We need some basic information about the assets and liabilities. And don't worry, we don't need valuations or anything like that. A reasonable estimate of the value of the assets is good enough. And if you don't have all the information about the assets and liabilities, that's okay. You can still apply. We simply tell the court that you don't have this information at hand. Thanks for watching. We really would love to help you with your letters of administration application. So get in touch with us for a free discussion to find out what you need to do.